Hello, Andrew Bethel with the Bethel Law Corporation, and as an estate planning law firm located in Southern California, the most common question we get asked about one of our biggest practice areas, probate, is just how much does probate cost? Now, typically these people are asking about our attorney fees for probate, which is actually a much simpler question, but the overall cost for how much probate really does cost to the family and to the estate is very complicated, and it's something we'll be getting into today. So just what are the costs to probate? Now there's a couple different areas where determining the true cost of probate comes from, and so we'll break those down today. First off, we have the court fees. Because probate is a court proceeding, you do need to pass through the probate court system, and that system is not free. You have to pay a filing fee just to open the probate, and in California, we now also have to pay a closing fee to close down the probate estate. On top of that, there's the miscellaneous fees that do get paid to the court in order to acquire certified copies of documents, which you're going to end up needing a couple going through the probate process. So those opening filing fees and the closing fees to the court are going to be roughly the same. Right now, they're typically around $465. But those have gone up over the years. And for those forms, those certified forms you need from the court, those are required in order to do things like close down bank accounts or sell real property. And you're often going to need a couple of those because institutions are going to want to see those originals. Now you have to buy those from the court. That's a smaller fee, usually around $40 or so, but when you start needing quite a few of those to hand off to different banks and institutions, that fee can start adding up over time. So on top of the court fees, we also have fees to other third parties. So one of the requirements for a probate in California is there has to be a notice published in a local publication, usually a newspaper, that someone has passed away and that there will be a probate hearing in order to appoint the manager of their estate. It's typically called a notice of publication of death. Now that's paid to a third party, and the proof of that has to be filed with the court. That third party fee, it's going to depend on the particular newspaper, but expect something in the realm of a few $100s. On top of that, you also have to pay what is called a probate referee. So that is someone that the court appoints to go out and value the assets of an estate. Now, if there's money in the bank, you don't need a probate referee. You just use what is in the bank, so the bank statements. But if there's something like real property or other type of commodities, an appraisal does need to be done. The court has their people that have gone through the proper training and licensing, and they become what's called a probate referee. And the court just goes down their list and assigns probate referees to each case. Now, those aren't employees of the court, so the estate has to pay that probate referee directly. And if that probate referee, if they don't get paid through the process, for instance, someone forgets to pay them, that probate referee is going to file a claim on the estate before it's closed down. So either way, if the manager cuts them a check or not, that person is going to get paid out of the estate. So there we have court fees, we have the miscellaneous fees to third parties. Next we have the attorney's fees, which are set by the probate code, which I'll get into in a moment. We have the executor fees, which are equal to the attorney fees. And the executor does have the option to waive receiving their fees. It's not uncommon for an executor, which in this case, just a manager, just kind of keep that in mind. They often elect to waive that fee if they're also a beneficiary of the estate. But they can collect the fee, and it's the same as the attorney. And finally, there's a cost that isn't really a monetary cost, but it is something you should keep in mind, and that is your time. Probate courts in California are very busy, which means we need to fight for every available court hearing date. That does mean that court dates get handed out months down the line, so it's not uncommon for us to get a hearing notice in, say, October, but that hearing date isn't until January of the following year. So in California, it depends on the county, of course, but typically we're looking at anywhere between 9 to 12 months to close down a probate. Now that's start of the probate, that's not from date of death, start of probate to closing, paying the money out to the beneficiaries and any final expenses. About 9 to 12 months, which is a long, long time. It does wear on our clients. So I mentioned attorney fees. They are set by the probate code in California. So what that means is that no matter which attorney you go to, whether they be in Newport Beach, Redding, Palm Springs, or here in Redlands, the fee for that attorney for the probate is going to be the same. Now other states do it a little bit differently. Some of them allow attorneys to just submit a bill for their reasonable fees and the court will approve it. But in California, the fees for attorneys are set by the state probate code and it's done by a formula. Now firstly, to even get into probate, the estate has to be worth over $166,250. If the estate is below that, there is an expedited process that can be done to avoid having to go through probate. But anything above that does have to go through probate. And as a general rule of thumb, if there is real property, expect to be in probate. So even though the estate, even though a probate proceeding cannot be opened till $166,000 is met in terms of the value, attorney's fees get calculated a little bit differently. So for instance, or actually, the probate fees are based on a percentage of the value of the estate. So that's 4% for the first $100,000, 3% for the next $100,000, 2% for the next $800,000, 1% for the next $9 million, and we get up to higher numbers at that point. So 0.5% for the next 15 million, and anything above 25 million, at that point, the court is going to determine what is the reasonable fee in order to pay the attorney. So I just threw a lot of numbers at you, so let's go through some examples. So here we have an estate that is worth about $500,000. Now this is just a ballpark example. Of course, nothing's going to be quite that flat or even of a number. But in a $500,000 estate, the attorney fees in that situation is going to be $13,000. And as I mentioned before, the executor or the manager of the estate is entitled to the same fees the attorney is entitled to. So that means is that $13,000 can easily double to $26,000. On top of that, we have those other miscellaneous fees that I mentioned at the onset. That's those court filing fees or fees to other third parties. That's another, on average, maybe $1,500. Sometimes it gets up to $2,000, but in this instance, we'll just say $1,500. So at the end of the day, a $500,000 estate passing through probate right off the top in fees is going to cost $27,500 plus at least 9 months of everyone's time. Again, nothing can be distributed until that closing approval by the court, which means you cannot distribute anything till the close of the probate, which is going to be about 9 to 12 months. Here we just say about 9 months. Additionally, here are some other examples. So for a $350,000 estate, the cost of it can be upwards to $21,500 plus 9 months of everyone's time. In an estate worth $750,000, the potential cost is up to $37,500 plus 9 months of someone's time. Or if you have an estate that actually comes out to a value of $1 million, the fees can go up to $47,500 plus 9 months of someone's time. And if you have an estate worth about $1 million, expect that 9 months to balloon past 1 year. All right, so now we've talked a lot about how the attorney's fees and executor fees are determined, as well as what miscellaneous fees to kind of expect on top of those through a probate. But I've kind of mentioned throughout this that attorney's fees and executor fees, or the managers, their fees are based on the value of the estate. Now, I didn't specify gross or net. A lot of times people figure it's the net value of the estate. So for example, a $500,000 estate, let's say that's just one house and it has a $400,000 mortgage on it, that means there's only $100,000 net in the estate. Unfortunately, the probate code says we do not look at the net, we look at the gross value of the estate. So in that example, that $500,000 home that gets sold for $400,000, leaving $100,000 in the estate, the attorney fee is determined off that $500,000. So even though there's $100,000 left, 13 grand is going to come off the top to pay the attorney's fees, or can be doubled to pay the manager's fees. So in California, we determine the attorney fees and the executor fees on the gross value, not the net. All right, so we've talked a lot about how to determine the attorney's fees and the executor or manager's fees, and how those are set by the California Probate Code based on the value of the estate. The next question is, well, how do we arrive at that value? A lot of times our clients come in thinking that how we get to that value is we just see what's in the account at the end of the probate, and then we determine fees from that point. Fortunately, that is not how it works. In California, those fees are based on the gross estate value, not the net estate value. We look at the total value of all the assets in there, and we do not deduct it or lower that amount by any outstanding liabilities before determining the fees. And that also means that any creditors that crawl out of the woodwork and make claims on the estate, once those creditor claims get paid, that also does not reduce the value of the estate. Again, gross value, not net. So as an example of how that would end up playing out is, let's go back to our $500,000 estate example. In that example, let's say we just have one house and it's worth $500,000. But there was a $400,000 mortgage on it. So upon the sale, the house sold for $500,000, but $400,000 went to pay off the mortgage, so leaving about $100,000 left in the estate. Now that $100,000 is the net estate value, not the gross. In that situation, the gross estate value is $500,000, and that is the number that determines the attorney fees and the executor or manager fees, not the $100,000. It's a very important distinction because it can often cause kind of a shock to some of the family once they see what the gross value is, or they see what the net value is at the end, but then they realize, well, you still have to pay all these fees, because what that is doing is it's taking money out of the estate, which means there's less to pass on to the beneficiaries. So again, determining the value of the estate, we have to look at the gross value, not the net. Finally, when we get asked, how much does probate cost? The short answer is a lot. There's a lot of different fees that go into actually calculating that final number at the end of the day. But just as something to kind of keep in mind, those miscellaneous fees, which encompass the court fees and the fees to other third parties, that's going to be about $1,500 to $2,000 just out of pocket, just to get things moving through the court system. On top of that, there's the attorney fees and the executor or manager fees, and those are based on the gross estate value. Finally, we have the time. As I mentioned before, probate courts in California are very busy, and it's not uncommon to where it takes us at least 9 months to have an estate pass through the court probate system, and most of the time it's just because that's what we have to do. We have to wait on the court's calendar. Even though we might be done, we still have to wait 3 months to get the hearing, to get the judge's order to say, all right, looks good, you're actually done. So at the end of the day, probate, it's very complicated in terms of determining the cost because there's a lot of different things that go into it. But attorney fees and executor fees are set by the probate code. You have your out-of-pocket fees to pay for the administration, and then just be ready to wait. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.